Fast forward, ini como our channel so AG Politics Avenue. Podcast or say training make headlines. Only any jemre na yidi bi exomo ewa ha. Nidi mi ho braxi mu se ene edi di kanyam. Stay so bit ma subscribe to the channel. Hit notification bell so share na afa from so answer into min kebi. Edi di mu ni ho braxi mu a. Only am stress say yonko yin simu. Ene me no ka say ya break amount ewa ye channel yin so say remove Chief Justice Torkornoos etim initiate legal proceedings to prevent the vetting and appointment of Chief Justice Paul Bafuboni as the next Chief Justice. Na meno kase sase musi ena abujafo atransia lawyers akukudam atransia ene omo ejimu chirimu ebo mu chirimu a yedibi enso esomu a omo che the back and forth of the entire matter. Mr. say yonko yinsemu.
Thanks for staying with us here on The Pulse. Well, this afternoon, the former Chief Justice, Gertrude Araba Torkornoos, has filed a suit at the High Court seeking to halt the vetting and appointment of Bafuboni as a new Chief Justice. She's asking the court for several reliefs, challenging both the legality and the grounds for her removal from office as head of the Supreme Court of Ghana. Well, let's delve into this. Joining me in the studio now is member of our legal affairs desk here at Torkornoos, Kweku Asante, joining me just to break down this. Kweku, you've been going through it, quite a lengthy one, 278 pages. Let's try to do justice some of the key concerns she's raising in this suit.
So let's start first by talking about the reliefs by way of judicial review that Madame Torkornoos is seeking. And just by way of recap, the Chief Justice, in fact, the former Chief Justice, Gertrude Torkornoos, has been removed from office for some months now because the Pullman committee that looked into the matters decided that for some reasons there was stated misbehavior on her part, for which reason she could no longer remain in office as Chief Justice. Mind you, Article 146 says the President is bound by the recommendations of the committee. So the President really did not have a choice in this matter but to comply with the recommendations of the Justice Pullman Committee and remove her from office. And so by a warrant signed by the President, Madame Gertrude Torkornoos was removed from office as Chief Justice and has since then not been serving. And we know that Justice Bafuboni has since been nominated as the next Chief Justice. And with Parliament set to resume next week, it is very likely he will be vetted within the next 2 weeks. So let's get into some of the actions. And this is the first legal action that Madame Gertrude Torkornoos is filing, that is fighting frontally the findings of the committee. And so she's asking for three main reliefs that goes to the work that Justice Pullman's committee did, and then another that goes to what Parliament may decide to do in the future. One, she's asking for an order of certiorari, that is an order of a court that quashes the decisions of a lower court or an administrative body for the purpose of being quashed, the proceedings of 15th of May and the entire proceedings and outcomes of the Article 146 committee set up to consider petitions to remove the applicant chaired by Justice Pullman. In plain English, Madame Gertrude Torkornoos is asking the High Court to, by an order of certiorari, quash everything that Justice Pullman committee did. And that five-member committee, including the former Auditor General, all the work they did. Madame Torkornoos is asking that all of that be quashed. Two, she's asking for an order of certiorari for the purpose of being quashed and for quashing each and all of the three grounds given by the Pullman Committee for recommending the removal from office as Chief Justice. The Chief Justice was removed on the basis of certain three grounds that were found by the committee. And the Secretary to the President wrote to Madame Torkornoos saying that she has been removed from office by virtue of those three grounds. This suit that has been filed by the Chief Justice says those three grounds must also be quashed. The third one is an order of certiorari quashing the warrant by the President dated September 1, 2025, removing her as Chief Justice from office. And so she wants consequently the removal of the Chief Justice to be also quashed. And then the fourth one, an order prohibiting the consideration and appointment of a new substantive Chief Justice of Ghana. That means the nomination that we know now will go to the Parliament of Ghana for Mr. Bafuboni, the acting Chief Justice, to be vetted and if approved to assume office as Chief Justice. Madame Torkornoos is saying that that process must all be put on hold. In fact, it must be suspended, it must be quashed, because it doesn't have any legal basis and any others. Then now let's get into the grounds that the Chief Justice, the former Chief Justice, I keep saying Chief Justice, is canvassing for this new action that she has, through lawyers, Edukusi, filed in court. She says that all the alleged findings and grounds for recommending that she be removed do not meet, and I quote, even remotely, the standard of stated misconduct, incompetence, or infirmity on ground of inability to perform the functions of office imposed by Article 146. That is one ground. And that the finding and recommendations of the Justice Proman Committee violate, and he says blatantly violate, relevant provisions of the 1992 Constitution. Third, the first alleged finding and recommendation of the Proman Committee is false, misleading, irrational, and unreasonable and illegal on account of purporting to find, quote, misconduct of the Chief Justice for expenditure that has not been disallowed against the Chief Justice, nor the Chief Justice surcharged for aid by the Auditor General in the audited accounts of the judiciary. Then, again says, the first alleged finding and recommendation of the Proman Committee is false, misleading, irrational, unreasonable, and unfair on account of purporting to find stated misconduct. Then, 5, the first alleged finding and recommendation of the removal is again unfair, unreasonable, illogical, irrational, perverse, and absurd, and therefore unconstitutional and illegal on account of purporting to find misconduct on the part of the Chief Justice when the legitimate expenses on the Chief Justice vacation were administered and authorized by the Judicial Secretary, Director of Finance, and other people that she mentions in this section. And then goes ahead to say that the issues that have been raised by the Proman Committee, and specifically, let me quote this part, is very interesting. She says, the finding and recommendations of the said committee constitute an abuse of power and therefore unfair and illegal, and breach the legitimate expectation raised in the applicants by the terms of the appointment of as Chief Justice of the Republic by the travel policy. Then she goes to the second finding. It says that the second finding constitutes an abuse of power given to the committee and is unfair, unreasonable, perverse, and absurd because she says she's allowed to transfer judges and other officials of the judicial service. Then the third finding is breaches the exercise of the legitimate obligation placed on the applicant by Article 1254 as head of administration and supervision of the judicial service. It goes on and on to say that the 3 alleged findings and recommendations for removing the Chief Justice from office by the Proman Committee are false, misleading, irrational, absurd, and perverse in the Wensbury sense. The entire findings and grounds of the said Proman Committee for removing the Chief Justice from office are in violation of the applicant's constitutional rights contained in Articles 19.3 and 23 of the Constitution, and that the proceedings of the committee violated Articles 23, 296, 146.3, 146.7, 281, and 295 of the Constitution, and therefore illegal, void, and of no effect, having been conducted in breach of the rules of natural justice and as adversarial proceedings under Article 146. And then finally, that the entire proceedings of the said committee were conducted with substantive and fundamental procedural irregularities and unfairness that renders the findings and recommendations a nullity. So for Sina, Madame Torkornoos is in court, and ultimately her case is that the principle and the issues that were raised ultimately by the Justice Proman Committee that led to her removal from office are absurd, irrational, unconstitutional. They breach the Constitution and therefore must be set aside. And if they are set aside, she wants 3 things: that Justice Bawumia should not be considered and appointed as Chief Justice. Ultimately, she should be reinstated as Chief Justice, Faustina.
Thank you so much, Kweku. And this document is quite lengthy, 278 That's how long it is. And so we'll be delving into it. We'll be reaching out to counsel for the former Chief Justice here on The Pulse. But it's a good time to bring in Kwekwan Sasari, former director of the Ghana School of Law. We appreciate your time here on The Pulse. You've just been looking through this document, quite lengthy, but let's look at some of the concerns she's raising. She's raising concerns about Justice Puamang's committee and the grounds for which they declared that she was involved in that, quote, stated misbehavior. She uses quite strong words that the report is false, misleading, unfair, unreasonable, perverse. Quite strong words to describe a report. And it raises a lot of questions. But from where you sit, let me take your initial reaction to this report.
Thank you very much. My initial reaction is she's
to this suit she's filed.
To tell Ghanaians that at the time she was appointed by former President Akuffo, she former Justice to Torkornoos not for purpose. She's displaying a lot of emotional imbalance and immaturity. She has to realize that the seat of the Chief Justice is not a traditional stool that the occupant can claim as a right. My initial reaction. But more on, the legal terrain. What she's doing is merely seeking to re-argue, rehash, a case that she fought fiercely before the Puama Committee. Now that the Puama Committee has submitted its report and the President has accepted the report and the recommendations contained in it, they cease to be Puama findings. They now become the decision of the President. And the decision of the President was taken in accordance with the Constitution. It cannot be questioned. Nowhere in Article 146, clauses 1 to 11, that give a right to question the President's acceptance of the recommendation. So, period. That must be the end of the case.
That is not the end of the case, is it?
Activate the process.
But for her, that is not the end of the case, really, because she's concerned
that must be the end. She should be told that she has come to the end of the road.
So she's raising concerns that even the recommendation that the committee gave, their findings was flawed. And that flawed findings is what the President acted upon. So she wants the whole decision of that committee to be squashed by the court.
Is merely reactivating, something that cannot be reactivated. The case is dead and buried, and nothing she does will make the dead case turn in its grave. I'm sorry to, make this observation, but a former Chief Justice must understand that she's bound by the Constitution. If he does not appreciate the EJ removal process, if she cannot observe it, she cannot respect it, she's only demonstrating that when she was appointed, she was immature. And because she was immature, she's, suffering all this things. She has to stop. She has to stop. Now, the grounds are frivolous. The entire action is vexatious and frivolous. She must know that in law, there is something called res judicata, and she's caught by res judicata. She cannot resurrect, the case. The President, has acted within the confines of the Constitution. What he's trying to do is purporting to prevent or prohibit the President from discharging his constitutional obligations and duties. The nomination of a CJ is not a presidential privilege. It is a constitutional duty, a constitutional obligation that must be performed. The vetting process is a constitutional duty. It is an obligation. It is not a right or a privilege of the Speaker to convene Parliament for the sole purpose of vetting the President's nominee, for consideration as Chief Justice of the Republic of Ghana. And therefore, her latest action is flawed. It will not go anywhere.
But then here's the concern, really. Should she go to court and the court finds that some of the concerns she has raised, especially about the committee's report, and then we have a situation where we have already vetted and approved a new Chief Justice, what then will play out in that scenario, really?
But what is it, in the Constitution that after the President has accepted and acted upon the recommendations of a committee established pursuant as the 146, any court, can assume jurisdiction to rehear the matter? Nowhere. This latest action, is again dead on arrival. I mean, nowhere. No, the court will have jurisdiction to entertain, this frivolous and vexatious application.
So even when she has filed the suit at the High Court, they lack jurisdiction to hear this matter. Is that the case?
The High Court doesn't have jurisdiction in this matter. This is a pure and simple Article 146 CJ removal process. The tagging of Article 123 to a sympathetic discretionary measure is neither here nor there. Article 146 is not, a discretionary thing that, one can fall on the spelled out by the Supreme Court in the Bawumia and West African Examinations Council case. Sorry to make this observation. But again, I mean, it is only showing our lack of understanding of, the provisions enshrined in Article 146. And for a whole Chief Justice to display this ignorance, the nuances of Article 146, it's mind-boggling. I'm sorry that I'm being too severe on the CJ, but I think that, what she's doing, is creating a caricature of herself. And she must be told in plain language that the office of CJ is not a personal property. And therefore, she cannot stop the President from proceeding to perform or discharge. Indeed, if the President, fails to discharge or perform his constitutional duty by virtue of Article 144 Clause 4, he, the President, will rather be in breach of, the oath he subscribed to the good people of Ghana. And that can be an impeachable offense for not enforcing, the Constitution or, observing, the Constitution, that integrant of the oath. That is subscribed. But
Mr. Sasari, the Article 146 is clear, really, that you must be able to establish, quote, stated misbehavior. And that's the whole argument of the former Chief Justice. She argues that she never indulged in anything that would have warranted that, quote, stated misbehavior for which the committee recommended her removal. So even though the nuances of Article 146 exist, there are concerns that an injustice may be ongoing beneath our nose, and we're looking at it unconcerned. That's the reason why she's challenging this in court. You disagree?
I do. I don't agree with that at all, because you see, there are needs. She started with the committee, she went to court, she went to the High Court, she went to the Supreme Court. The public policy of Ghana is that there must be an end to litigation. And she superintended the judiciary, and she, at every step in the discharge of her duty, usefully reminded herself always that whenever litigants will appear before her, she had the duty to remind them that litigation must come to an end. Litigation must come to an end. Her litigation in this regard came to an end the moment the president accepted the recommendation and acted upon it. That brought to an end. Whatever she does now is only, making ugly noises, which will constitute a social nuisance. That will be the effect. Complete social nuisance and a mess, of, her legal prowess.
Thank you so much, Kwekwasa Asare, former director of the Ghana Law School, just joined us here on the Pulse. If you just tuned in, we told you that the former Chief Justice Gertrude Araba Torkornoos has filed a new suit at the High Court. She's seeking to halt the vetting and also the appointment of the current acting Chief Justice Bawumia. And we've just been trying our phone lines to try to reach the legal representative for the Chief Justice. When we do, we expand the conversation because we have key questions really. Has she been able to see that committee report for which she's challenging the grounds for which they made that recommendation to the presidency? Key questions we want to ask their team this afternoon on the Pulse. We also want to find out concerns being raised by Kwekwasa Asare that even going to the High Court is dead on arrival, really, because they lack jurisdiction. They take that into consideration while filing this case. That's a conversation we'll be having when we reconnect our lines and try to get them here on the Pulse. Well, away from that, but still on legal issues, the arraignment of the former National Service Authority Director General Osei Asibe-Antwi and his deputy Gifty Oware-Mensah was delayed after different issues were raised in court. In the case of the former Director General Osei Asibe-Antwi, his lawyer appeared before the High Court today, informing the court that his client had been instructed to report to police investigators in Kumasi and was currently there. Meanwhile, in the separate case involving the former Deputy Executive Director of the NSA, Gifty Oware-Mensah, the court was informed that she had presented a 2-day medical excuse duty. In 2 separate court documents filed at the High Court in Akroma, the state accuses the former Executive Director, Osei Asibe-Antwi, and the former Deputy Executive Director, Gifty Oware-Mensah, of orchestrating 2 distinct schemes that siphoned public funds through ghost service personnel as well as fraudulent bank loans. While still in court, the former National Signals Bureau boss, Kwabena Idu and his attempt to put his trial on hold failed as the High Court dismissed his application for stay of proceedings.
After today, lawyers for Kwabena Idu had made certain applications before the court. They were asking for certain documents, certain disclosures that they believe will help them make their case. The judge in this matter, Justice Nyante, had denied them that application and denied them those disclosures. And they decided that they were going to file an appeal at the Court of Appeal to challenge the decision by the trial High Court. For which reason they came back to the High Court and asked for a stay of proceedings, which simply means that they wanted a trial to be put on hold pending the determination of the matters that they've taken to the Court of Appeal. Today, Justice Nyante reasoned that there's no reason to put on hold this trial while that appeal succeeds at the Court of Appeal and therefore dismiss same, which has meant that that trial is expected to continue. And in fact, prior to today taking about 1 hour break, the case was continuing and the state had called this next prosecution.
We and some who team course watch and so Mamma so Jimre or had a send so bad in the Dumbi Edomiania, but some room near some constant Sokra, EGH Politics Avenue.